Okay, let's see. Appearance for the record.
Your Honor, Mark Demarest, previously representing Brandy Borders, although we have a motion to withdraw. That's one of the motions for today.
Okay, Ms. Borders is the defendant. You're on the plaintiff's side.
I'll serve it.
What's your name?
James Murray, standing in for the attorney of record, Darwin Fair, PA 5490, on behalf of the plaintiff.
Thank you, Mr. Murray. Okay, and so now, Ms. Borders, your name?
Borders.
Okay, all right, so we've got several things going on here. There's motions everywhere. You want to withdraw?
Yes.
And then there's motions regarding this escrow. Let's deal with the motion regarding the withdrawal. Go ahead and make your argument for the withdrawal.
Yes, Your Honor. Ms. Borders filed a motion, alleging that we somehow stole money from her. I have no idea what she's talking about and certainly deny those allegations.
Mm-hmm.
But given the nature of the allegation she's made, certainly there's been a breakdown of the attorney-client relationship. I cannot continue to represent it.
Do you have any objection to his withdrawal?
Yes, I do. Actually, the day of my closing on October 23rd, he was supposed to show up at the closing, and the last minute, my realtor, Michael Ramirez, said that Mark Demarest is not going to be showing up. And I said, why not? He has another engagement to go to. So that day, I terminated him myself. I was really upset. I have information here.
May I respond to that? One, I never told anyone I was going to be at the closing. There was no need for me to be at the closing.
Right, probably not.
All the documents had been reviewed ahead of time. I don't know who Mr. Ramirez is. I've never spoken with him. And Mr. Borders did not say anything to me. I talked to her during the closing by phone. She did not say anything about my being there. She did not say anything about termination. I also talked to her the evening after the closing. She had a couple of questions. Never said anything about termination or why I wasn't at the closing. There was never any expectation I was going to be at the closing or any meeting. But I don't understand how that would be, her comments would be a reason for me to be required to remain as her attorney. It seems the opposite.
Yeah, that's what I was thinking. Well, if you already terminated him, then you certainly don't object to him withdrawing to represent you then, do you?
No, well, it was on October 23rd, and then after when I sent him the motion that I don't want to, like when we went to court last, when we were on Zoom, that he had somebody else, and she said she never knew that he was fired from being my lawyer. But he does know who Mr. Ramirez is because I have several emails. That's my realtor, and Sharon's his assistant. So we had tons of emails and group texts, emails, Your Honor. And when I looked at the numbers, that's why I was like very angry. And I didn't even know what I was signing because I thought he would be there to look over the numbers as my attorney.
He says he looks over everything ahead of time.
No, he said everything is credited. So I purchased a home for $160,000. We've been dealing with this for 5 years with you, Judge Johnson, because through the courts with the building department. Okay, that's one thing. Then what I explained to him, why would I have to, I was living in Canada then, 2015, 16, 17, summer of 18. Why am I paying this man's back taxes. I discussed this with my attorney. Oh, no, it's credited, everything's there. I made 55 payments, Your Honor. The balance was 130 5 years ago. Why would it be as today $130,000? I explained that to my attorney. So, Mark Dennis, I'm sorry. And that was credited back to you. I said, okay. Does it say dummy on my forehead credited back with interest and everything? No, everything in the interest, everything was in there. We paid everything. So I'm upset. All the building department, all the stress throughout the years, okay? Then I tell him this. No, everything was credited back. I said, can you understand your credited? What does credited mean? Subtract 55,000 plus 23,000. Can you please explain this to me? I gotta calm myself down because I've been through so much, Your Honor, so much throughout the years through my divorce. And when people just take it, and I'm tired of it. I'm so tired of it. I explained to this man several times, why wasn't this done? Oh, everything was credited, Mrs. Borders. And Your Honor, when you had Denise that was here, your previous assistant, she gave us the information during COVID when we were with Derek Rindles. We were telling him about the back taxes. Everything's in there. I gave Mark Demers $21,000. 3 weeks later, with that $21,000, he should have gave the balance to $5,000 that we owed Rindles. No, but he kept that money. 3 weeks later, they paid the back taxes. Everything's in there. We paid the back taxes. So why wasn't my $21,000 taken? Then he tells me, knowing that me and my ex-husband separated, that, oh, yeah, Eric owes me $18,000. I said, how would he owe you $18,000? I got every email. I said, these numbers are not right. It's $5,000. Eric tried to go after him to argue with him with his attorney about this. So I said, you know what, that's okay. I had to borrow $11,500 from someone to give the money. I gave him $11,500. He kept $5,000. I said, okay, why wasn't the $5,000 deducted off the money? Why wasn't it? Why wasn't the $21,000 back in 2021 was to go towards rentals? Oh, it was credited. I said, okay. And this is why I said, no, I'm tired of people taking from Your Honor. I went through HELL through 5 years, not 2 years, 5 years, which is people just taking and taking and taking. Everything was credited. I said, okay, I'm not stupid. Okay, I'm not stupid. I said, where did my money go? Where did that money go for the last 5 years? Where did it all go? Can you please explain to me?
Okay. Well, obviously, we're not going to answer all of those.
No, I know, I
questions
understand.
today.
Everything's in there with everything throughout the years.
But I guess that's her explanation as to why she feels, I guess, that money was, quote, taken from her. But if you have this kind of a situation where you believe that you gave him money and that it should have gone to the plaintiff, at least a large portion of it, from what I'm hearing, should have gone to the plaintiff, then you certainly don't want the man to represent you anymore, correct?
Correct.
He denies what you're saying, obviously, but he says clearly he didn't understand where this argument was going. Maybe he understands what you're saying now, I don't know. But he's saying that clearly there's been a breakdown in the attorney-client relationship at this point. Would you agree with that?
Your Honor, no. I
You don't think there's a breakdown between you and him communicating at all?
No, I have communicated. I've screamed.
Okay, so you wanted to stay as your lawyer? Did you think that?
Well, I wasn't with him.
You think everything that he can represent you well, and that you all are talking well about all these issues that you just said you had a problem with. Now you're saying you don't have.
No, I had a problem with it at the end until I found out.
Okay, so right now, do you think that you have a breakdown in your relationship with this lawyer?
Yeah.
Well, that's all I need to do.
Yes, I'm sorry.
Because he says he thinks that too. So based upon that, I will let him withdraw as your lawyer for today. Did you have an order prepared?
I do, Your Honor.
Anything else that you all have arguments about? Well, that's not this case.
Yeah.
That's potentially another case between you two. Yeah, you come on, right up. Okay, Mr. Demers. All right, so the order basically says that we had a hearing today and that the motion to withdraw is granted, and that if you need a new lawyer, that we would give you 30 days to find one. Did you need to get a new?
I think that can happen, but I was just wondering, can we get this resolved today?
I don't know.
Because I've been waiting
I'm
for
here to
this.
try to resolve it.
No, everything's in there, the proof, because at the closing,
Okay, ma'am.
okay, go ahead. I'm sorry, John.
We'll give his order. We'll let him out. I'm sure he doesn't want to stay for this.
Well, although her motion does make allegations about me that I.
Also, then you might want to stay. Okay.
Yeah, definitely want to stay.
Okay.
I just can't be her attorney.
All right. So now we got motions for the return of the escrow. All right. Now I got something that I just saw today. Defendant's response to plaintiff's motion to release the escrow fund. So I've not read this.
And I have not seen it either. John.
Nobody has seen it. Apparently, from what I just heard, someone did not file it at the clerk's office, which you have to file everything at the clerk's office. It appears that it was filed or sent to my assistant, who's been out of the office and is not checking her email. That's why we don't file through assistants. We file at the clerk's office. So no one has read this from Mr. Fair's office. And I think everybody would need to understand the argument.
Is that something that Ms. Borders submitted, Your Honor?
No.
That's something that Attorney Fair submitted, however.
Oh, I have seen, you said defendant, I thought.
It does, that's what it says.
It was the plaintiff's response to the defendant.
Oh, yeah, wait a minute, here, where is that? Yeah, plaintiff's emergency motion, and then, okay, where's the,
So the emergency,
I know what her motion is, I'm thinking.
I have seen the response from Rendell's development. I misunderstood what you said.
Okay, wait a minute. Okay, here it is. Brief in support of plaintiff's response to defendant's motion to clarify finances for land contract and debt owed to.
Yeah, I have seen that, Your Honor.
I haven't seen it. You got it, but we just got it.
Understood.
So, because of the fact that it was sent to an assistant apparently. So, I mean, to the extent that you all want to make some argument, I haven't read this.
Your Honor, that simply restates our motion to release escrow. So our original emergency motion pretty much outlines what needs to be discussed.
Okay. Well, do you want to make?
Yes, I disagree with that because Rendell's got paid $130,000.
Let's start from
$130,000 at closing. He already got paid. And then 2 weeks later, when I mentioned it to Mark Demers about the money in escrow, Rendell's comes and says, I want emergency money. I said, why would he get the extra money that I've been making the escrow payments? And I told you a couple days before, I want that money deducted out of the closing. I don't want it to be taken out of the closing, but it was taken out of the closing. And then you get your check and then you come back around to take the money downstairs for that too as well. Oh, everything was credited. I said, can you stop with the credited? What credited?
Okay, well, I don't understand most of that argument, but all I know is we've got approximately, I guess, $8,000 some odd dollars here.
Your Honor, if I can elaborate.
Oh, wait. So we got $8,000 that Ms. Borders wants that because she says everything's been paid and satisfied. Apparently, the plaintiff says they still owe money.
Yeah, I can address that, Your Honor. Is prior to the closing, I reviewed the payoff letter and all the calculations.
Okay, wait a minute. So
Yeah.
prior to the closing, the payoff, supposedly, there was something in the file that I saw that said the payoff was $32,000.
And then it went to 123 because he said he spoke to Rendell's to take a few thousand off. I said, few thousand, I don't even owe him that amount. He wasn't supposed to get that amount. Where's my 55 payments? 55,000 throughout the years of 5 years. that was supposed to be subtracted, but you know what he said? That was credited.
Okay, wait a minute. Let me find the, we need to look at the complaint, the judgment.
The judgment was actually a forfeiture judgment, Your Honor.
Right.
No, it wasn't a foreclosure.
Yeah, it was a forfeiture for $9,108.20.
Right, and that was just the amount of the payments that were late. If that wouldn't reflect the balance.
It's okay. So the way I see it, we had a judgment of possession. After the land contract forfeiture, that was 32,681.93. That was back in May of 2022. Then in January of this year, based upon that original judgment, including unpaid taxes, which somehow should have been excluded from the judgment, we entered an amended judgment of possession after forfeiture for $9,108.20. And we entered it non-protunct back to the original judgment date. And the circuit court said, no, we should have entered it from the date that, whatever that date that was, forward. I said, send it back for us to enter it from that date. And give Ms. Borders an additional time, but since then, everybody has already settled this situation.
Yeah, what happened, Your Honor, is that once the circuit court entered that order, I told her she could then list it for sale. She listed it for sale, she signed a purchase agreement. And then when we get to the closing, we're preparing for the closing. I get a payoff letter from rentals. I review it to make sure it's correct, which I did, and all the payments have been credited. I think the issue that Ms. Borders seems to.
Is that this letter here from October 19th?
Yes.
That says 123,000 is the final payoff?
Yes, and that was actually reduced a little bit. I negotiated a reduction.
Okay.
But then as I did the calculations, I think what Ms. Borders is overlooking is interest. There were long periods of time where no payments were made and a lot of interest accrued. So as I was preparing for the closing, I made sure that the amounts that had been paid by Ms. Borders were credited. And that but when you add in interest and other, items, particularly interest, I verified that the payoff amount was correct. I negotiated reduction to put a little more money in Ms. Borders' pocket.
Why wouldn't this payoff amount then include the interest and everything else?
It does.
It does.
It does.
So the 123 is supposed to be the right amount.
Correct. And
So
then,
why is it that the plaintiff is still entitled to more money?
well, the escrow payments were also credited. All the payments,
There's
including the
nothing
escrow
in
amount.
this letter that says the escrow payments should be.
There's a calculation that's attached to what was filed by Rentals that shows that the
escrow money was included in this?
was credited to reduce that. So it would have either been, there would have been more money taken out at closing,
Okay.
or there would have been less taken out at closing and Rentals gets the escrow, because those were payments toward the land contract
I understand
that were credited.
supposedly what they were,
Yeah.
but the way this looks, at least to me, was that 123 was the payoff. 123 was paid. Arguably, there's nothing in the letter that mentions this includes the escrow amount. This excludes the escrow payments.
That is true, Your Honor, that the letter was to tell the title company what amount to take out of the proceeds at closing. The calculation that I went over.
You're talking about this calculation?
Yes. Well, there are a couple of different calculations.
I don't know. This doesn't mean a thing to me. I don't know what this is.
But I did verify that credit was given for those payments toward the balance, and that's where it was actually about 125,000. I negotiated
Down to the 123.
123. Ms. Borders saw the
And the
closing.
123 is supposed to include what she paid plus the escrow.
Correct. The escrow, that number was based on Rendell's getting the escrow because those were applied in calculating the payoff amount. I guess the other point I would make, Your Honor, is that Ms. Borders had the closing statement. I think the closing was on a Monday or a Tuesday. She had the closing statement the previous week. We talked about them. She saw them. She went to the closing. She signed the closing statement. There was about $50,000 that she and her husband received from the closing. Plus she received essentially 2 months of rent, staying in the house for 2 months. If she thought the numbers were wrong, then she shouldn't have signed the closing statement and continued with the closing.
Your Honor, if I may add, Mr. Attorney Demers reached out, asked for a payoff letter for the amounts we taken out of the closing. That chart that I gave is an amortization chart for all the payments that were credited towards the land contract. So actually, correct. So I actually did Ms. Borders a favor by crediting her for the amounts in escrow to reduce her interest. So that final payoff amount came out to $127,540.03. Mr. Demers negotiated vigorously, and we came to a final number of $123,000, which gave Ms. Borders a $4,500 discount.
I see.
And that included it was supposed to be actually $9,000 escrow, because the escrow order was entered in February. We didn't have the sale of the property till October. So I credited her for 9 months, and when I called Southfield for this court, determined the amount in escrow was actually $8,000. The October payment was not, she didn't make an October payment. So the effect,
Although you included that here.
correct, for amortization purposes. I was under the belief that she made her payment for October. So the $8,000 in escrow, that $123,000 number for the payoff to be taken from the title company, had already gave her credit for the $8,000 that we would be receiving out of escrow. So that Ms. Borders could receive that $8,000 at the closing. Now we did it the other way. If Ms. Borders received $50,000, she would actually receive $42,000 at the closing, and then she would have received the money out of escrow.
Correct.
Okay.
So, and actually, at this point, if you take the $4,500 discount that we provided, plus the extra $1,000 that the board didn't pay in escrow, my client is technically still missing $5,500. But, at this point, we're ready to end this matter.
Okay. All right. Because what we did here was kind of assume that there was the land contract that we put in a calculator, assume that she made $1,000 payments monthly, but you're saying some were missed, so that would have increased some interest there. And then, so the balloon payment would have been October this year. We came up with on $130,000 land contract because she had $30,000 cash down. So we didn't put that in for interest. It was 7% interest. If she had paid $1,000 regularly, we came up with a balloon payment of $114,038.97. And then, not understanding what you all had told me now that you did, we subtracted that from the 123 and we had a $9,000 difference. So it was like, well, she paid it. It's negotiated properly and she paid what was owed. So I'm looking at, well, maybe the escrow should go back to her. But now that I'm understanding that you're saying that it was all included, the escrow was included in the amounts and actually applied to reduce her interest.
That's correct.
For late payments. And it came up to the $127,540. If you added the extra $1,000 that she actually didn't pay for October, it would have been more had you not done that.
Correct.
But then you gave them a little bit of a discount on the whole thing. So it looks like everything included the escrow amounts and the final payoff, which wasn't clear at all, considering the letter just said 123 and it didn't make any reference to, plus this includes the escrow.
Correct, and we want to, apologize for the lack of clarity in that, but we were creating that letter again for the title.
For the title.
Because me and Attorney Demers had an understanding and agreement on the actual amount payoff.
All right, Ms. Porter,
Okay, besides, I disagree with that.
you disagree with
I disagree with that, with what he's saying. Okay, another thing, can you please tell me, Your Honor, off 130,000 5 years ago, where's my 55,000 go for staying there for the 5 years? The interest was already included. Plus, I gave him $21,000 cash. He kept the 21,000 and the city of, Oakland County
Yeah, well,
paid that.
let me say this. I don't know anything between what you gave your lawyer.
I have
This
proof on
now
everything.
is about an agreement that was made between you through your lawyer and Reynolds. So if your lawyer had something that you think he should have given to them, I can't give you the escrow because of that.
But I only owed my, Derek Reynolds, it was supposed to, the balance was 70,000 on the house. Mrs. Bowers was was the realtor at the time. The balloon payment of, after 5 years was only supposed to be 90,000. 90,000. And then it was 127 at the closing. That's why I was upset. And then he said, I'll talk him down to 123. He was only supposed to get 90,000. We made 55 payments, Your Honor. I gave this man $21,000 towards to give him for the only 5 years, 5 months for their arrears when he had Gary Seghetti as his attorney last time. And the back taxes on the house. Okay, so the balance was only supposed to be 90,000. That's what I told Mark, that Mark Demers asked me, well, how much do you think he owes you? And I said it was supposed to be 85 to 90.
Whatever it was, quote, supposed to be, that's not what it was.
No, because they did, I had no knowledge of it. It's like I was taken advantage
The
of.
only thing I'm here today,
I know.
these are other issues. You all might have a whole nother lawsuit as far as I know.
Oh, I guess.
But this is not, I can't resolve that in this.
Yeah, but the
I don't-
$8,000, he was, Your Honor, it was 123 was taken out at the closing.
Okay.
And then he didn't know anything about it until I said something to Mark Demers. I said, Mark, what about my money in escrow? That was supposed to be subtracted. Oh, no, that was credited. I said, that was credited. Oh, I said, was it
Well, I
credited?
see
Were
what
you
they
gonna
mean
go wait?
now.
Were you gonna wait until everything was done for you to go back and take it? Is that what you were gonna do? Because Derek Reynolds got paid at the closing. He got paid and he signed, everything was done. It was at the closing, and once I mentioned something about my money in escrow, I said, why didn't you take the money out of escrow? Well, no, I think that belongs to him. I said, why would you think that belongs to him? So you're saying now I owe almost 140? So I owe him 140 after giving him 55
It looks
payments?
like the 123 included this escrow money.
So
It's
then,
not
okay, at the
140,
closing, and then I
you're
should
taking it as if it's 123 plus another.
Yeah, it's another,
8,000.
and then another 14 was taken, 14 from Gary Seghetti, legal fees, and then it said HUD housing, taken out of me and Eric's money. That was, yeah, it was taken out of the money, it said it was credited, yeah, it says it was credited in ink, but the numbers didn't change, so why would it be 30,000, 30,000, if it was credited, don't
But
you
you
think?
gotta show me why.
It's right in there,
No,
Your Honor, it's right on the list.
No, you gotta show me why, since I'm looking at the way they calculated all of these payments.
Gary Seghetti, that wasn't even my lawyer.
But,
Oh, they made a mistake, it will be credited back. I said, okay, so then it should be 45,000.
okay,
It shouldn't be 30,000 still.
okay.
On ink, it says that.
I can only go by what your lawyer negotiated for you. And their lawyer negotiated for Reynolds. I can only go by what the intent of those parties was. And you'd have to show me how that's wrong.
It's right, Your Honor, it's on there. It's like the calculation. It's not right.
Well, I don't understand what your point is, because I'm listening to what they're telling me. Your own lawyer at the time who negotiated this says that the escrow was a part of the 123 and it was credited in to make sure, because you didn't pay.
Yeah, but I didn't pay, but it says.
But
on-
if you didn't pay every month,
Mhm.
there's interest that accrues.
Oh, yeah,
Which is
interest, because I
extra.
gave him my money to pay. It shouldn't have been, we wouldn't even be here today if this man would have gave Gary Seghetti, Reynolds at the time, his $5,000, we gave Reynolds. That's why it says there, I got served for Reynolds came to my house, Your Honor. I'm cutting my grass after court. And I called this man, I said, why didn't Derek get his money? I know, but it makes me mad because I'm not stupid. And he tells me, oh, don't worry about it, I'll take care of it. Reynolds had his money, I was giving his money 2 years ago, 5 years ago. I gave him that money. My daughter's shoebox, I gave him cash, $21,000. And the government paid, Oakland County paid the taxes, Your Honor, you were here. Denise gave us in, we were approved. He kept Reynolds 5Gs and he kept the other money, he never gave it back.
Your Honor, what you say is not accurate. There was
It's on paper, numbers and ink don't lie.
any funds that were given to our firm to be paid to Reynolds were paid, and we have documents attached to our motion. The 21,000 she's talking about is fees that we were owed, that we were paid at closing. I worked on this case tooth and nail for a couple of years. You know, there were many hearings in front of you. They hired me the first time for a forfeiture case toward the end. I helped them save the house. Then the second case, they contacted me after there was already a default judgment. And we convinced you to amend the judgment, but you wanted to do it retroactively, which means they would have lost the house. So I appealed to circuit court. We won the appeal. If I hadn't worked for them for 2 years with hardly any payments, they wouldn't have gotten anything. And I said, I've got to stop working unless we can figure out something here. And they agreed to give me a lien on the property. And I continued to work to save the house for them. Invoices were sent every 2 weeks. There was never an objection to the invoices. By the time of the closing, the total amount that was owed was about $21,000.
To you?
To me, to my firm. And that was to pay those invoices. It had nothing to do with any payment to Reynolds. And the closing statement very clearly says.
Where's the closing statement?
I can give you, it's attached, I can give you a copy of it.
Your Honor, in that file, it says, I received your 5,000, I
Okay, you
received your
confusing me.
15,000
I
cash.
need him to tell me
I
what
know.
he's saying
Yeah.
at this point.
You got your money.
Yeah, so here it is, you know, it's attorney fee to Demarest Law Firm, 21,000.
It's gotta be attached to
Yeah,
somebody's.
it's attached to mine.
And I'm looking at,
It's,
is it attached to yours too?
it's testimony, well, not the motion you have.
The brief?
Oh, my response that wasn't filed is attached there. I can say.
Yeah, it's attached to my answer to the motion to clarify finances as exhibit 2. And the closing statement says,
I don't know whose motion I got. What number? I've got yours in my hand. What exhibit is it on yours?
exhibit,
No, on this,
I'm pulling it up now. Exhibit 7.
okay, here's 6. 7. Okay, so this,
Sorry. Exhibit 8.
okay, so here's the closing statement. Okay, so your point was.
may I approach your honor?
Yeah.
I can help you find it. So under miscellaneous, on the second page, there's an entry for attorney fee to Demarest Law Firm. There's also an attorney fee listed for Sagatti, but then there's a credit on the first page that cancels that out. So that did not reduce the amount to be paid. The Sagatti.
Here it is, 21,353.68.
For an attorney fee.
It says it right on the closing statement. That was attorney fee for his firm. So I'm not so sure what you're talking about, that he should have taken a portion of that. This is all here. This is what was agreed to, and this is what was in the closing. So I don't see how he was supposed to take a portion of that to pay rentals. So then we go back to what they did negotiate as to what your balance was, and supposedly was due. And this is after the appeal. Because right now, I think it's kind of moot for me to go back and enter an order that the circuit court says enter as of a certain day, if It has no effect.
Yeah, the property's been sold.
Yeah.
That order in the appeal gave her the opportunity to sell the house.
Right. Or got that here. So, and then after that, then it's sold. And it appears that everybody agreed, maybe not as borders, but council agreed that it was 123 after credits were given for the escrow. It was really 127 and some change. But you agreed to the 123, and really wasn't 127 because it might have been more. So she didn't make 9, she only made 8 escrow payments. And it appears in this accounting that it was all credited. That's what he meant by credited. I can see it now. So if it's all credited as a part of what the payoff was supposed to be, which did benefit Ms. Borders in a large extent because there's no interest calculated on any of that because it's considered to be, I guess, on-time payments. And let's see, to the extent, and these columns don't tell me exactly what they are, but
Left to right is the date.
then after that, yeah, you got $1,000, so those are the escrow payments.
Correct.
Then you got another column that has nothing but 124,000 at the top from June of 2022. You got another column, I think it's the number of days, I don't know what.
The number of days, and you calculate that times the interest per day, and that's how you get the number, the total amount due in principal and interest prior to the $1,000 payment. The
Yeah.
number on the far right would be the final.
I think the reason a lot of interest had accrued was that there were just long periods of time with them.
Where there was no payments.
Correct. We're all for litigation for maybe a year or
Because
two.
we were in the court, so it was getting adjourned. That's why I couldn't get the payments, we kept adjourning it, remember? As well on top of that.
Well, at this point, Ms. Borders has requested to clarify the finances for this contract and debt owed. And Reynolds has requested, once it's clarified, that the escrow belongs to them. I mean, it makes sense to me now. It didn't make sense to me before, but I think it makes sense now what the parties, and this is what everybody's agreed to. It was all up in the closing documents as to what the final payoff was.
Did you see the exhibits, Your Honor?
What exhibits?
That's everything that I had put in there.
But ma'am, what do you want me to do with this? I can't change the closing documents.
I know, but the amount wasn't even, that's not the correct amount.
Well, how can I deal with that here? I had nothing to do with that.
No, I
closing.
understand.
That y'all did that on your own.
Yeah.
And so you all made that agreement separate and distinct from this case. And so now you're asking me to say, well, they did it wrong. Well, if that was the case, sold the property.
I tried to go back and,
Well, you should not have signed off on any of these closing.
well, that's
documents.
why my attorney was supposed to be there to look over the numbers. And the reason why, I think in my heart, that the reason why he didn't want to show up, because the previous money I was questioning him about. Why didn't Reynolds get his previous money? Where's the $55,000 was, so you're telling me 55 during 5 years, 5 payments, it's supposed to be 60, but that's 55,000, that's supposed to be all
Ma'am,
interest?
let me just say this.
Interest?
I can only go by what it appears you agreed to here. If you think, and you're sure free to talk to a lawyer.
Oh, I already
If
have.
you think
I already
that you have
It's
some
not
claim against, I hate to say this, your former counsel,
Mhm.
then you're free to pursue that.
Yeah.
But I can't resolve it in this case,
Okay.
if you understand what I'm saying.
Yeah, I totally understand.
All I can do is see what you all apparently agreed to outside of this case when the house was sold. And it's all seems to be listed here on the closing statement, and it all seems to be.
But that was, the amount of the home wasn't before the closing, before I signed.
But it's
That's what my
got
argument was.
$123,000 for the
It
payoff of
wasn't,
the
that wasn't
land
even supposed to
contract.
be the balance, Your Honor.
You what?
My, 5 years ago was 130,000. So where did all those payments go? That's my question. Where's all my payments?
I don't know.
Okay,
I'm only looking at the closing statement.
I know, I get it.
Which
That amount.
Which you signed.
No, I signed because,
Ma'am,
Right.
it doesn't matter why you signed. You signed it. Which pretty much ratifies everything on the document.
so 55,000
I
just
don't
went down
know.
the drain for 5
I
years
don't
for living in
know.
that
I
house.
don't know about the 55,000.
Okay,
I can only tell you that you ratified everything by signing off on this. You could have had it corrected. You didn't have to sign
I
it.
was upset, my lord, I didn't know what I was signing, Your Honor.
Ma'am, that's, you know, ignorance.
If you-
Ignorance is no excuse.
No, it's not an excuse. If you know that you put so much money into the house and you dealt with 5 years with this property, that you, in the
you
beginning of
shouldn't
time, it was not, the numbers
You
weren't
should have
right.
held up the.
I hired a lawyer that was supposed to look over that. He was supposed to be present. And he claims that he doesn't know who the realtor is,
I can't-
Herm is, and you,
I can't deal with any of that. I can't deal with any of that, because that's
Yeah.
outside the scope of why
I
I'm
have
here.
all emails, I'm gonna print them all up for the next.
The only thing I can say is that it appears, based upon everything that we've talked about in this record, that, we've clarified at least the finances to my satisfaction at least, based upon everything that has happened here. You know, the payoff appeared to be the 127 and some change. It appears that the defendant was credited for the escrow in an amount more than what the escrow was. And then they ended up taking less than that amount via negotiations. Some $4,500 more was taken off. Because that one escrow payment wasn't made, then there's a little bit, even more of a benefit that the defendant received. So clearly,
I argued for a couple of days that before we had the closing, Your Honor, that 127 was wrong. Then he came back to 120.
well, ma'am,
And that amount
I
was
say
wrong.
this. I can't correct an amount.
No, you can't, I understand.
So you
I
keep
understand what
arguing
you're saying.
things that
I know,
can't correct.
I understand.
If you think that there's some.
You're going
wrong-
off by what's that, and then what's in the
Right, you
escrow, I get it, but
you
that's
gotta
something a whole
prove-
different.
you gotta
that
prove
I'm
a whole
getting ready to
different
get
case. That has nothing to do with this.
No, that's a separate case.
Right,
That's
but
fine.
it appears
Yeah, I got it,
that
I
Reynolds
understand.
would be, based upon this, entitled to the escrow,
Entitled to
and
it.
possibly more, which he says he's willing to waive. So I'm gonna go ahead and grant the motion for release of escrow over to a plaintiff for the reasons here stated on record. Do you have an order?
I emailed it, should be attached in the documents as well.
Your Honor, I also have prepared an order denying Ms. Porter's motion.
Yeah,
If I may approach.
okay. So this order says well, the clarified finances is denied, i.e. we're not releasing any money to her based upon what I can see. Those are separate issues that must be taken up differently and not a part of this case. And so let me see if there is attached to whatever I have here,
So the emergency motion should be an order for the next page.
not to the brief and support.
No, emergency motion, right under it. So the one that was filed with the court.
Orders, give her that. Emergency motion, there it is. Notice and hearing, order releasing escrow. Is today the 29th?
Yes.
Why am I signing the 30th? Oh, you know what? My calendar gets.
Your Honor, may I get my paperwork?
Yes. So there's one order. Second order. And did you also, I signed an order withdrawing this contract?
Yes, Your Honor.
All right, we think we're all set then. And so that should conclude this matter. And so we'll go off the record unless there's anything anybody else needs to say.
I know Your Honor.
Nothing further, Your Honor. Thank you.
And she'll get copies of the order for you.
Okay, thank you. Thank you for your time today, Your Honor.
All right, thank you for the clarification.
Yeah, afraid I haven't heard the last bit. Everything is documented.
Thank you.
All right, and Mr. Randolph.